Okay, well, let's get started. Thank you for joining us today. Welcome. For those of you who don't know me, I'm Yvonne Schwab, ACG Silicon Valley CEO. And as many of you already know, ACGSV is the leading business-to-business networking organization in Silicon Valley, providing connections, thought leadership, and enabling personal and organizational growth. ACG Silicon Valley is offering a variety of virtual events in the coming months. We invite you to visit our website at acgsv.org to see the full calendar, including an event on healthcare titled Innovation at the Edge, our annual Deloitte Digital Media Trends event, as well as a panel discussion on microgrids. We are also co-hosting a golf tournament with FEI Silicon Valley on October 26th. And of course, COVID guidelines will be followed. So if you want to get some fresh air and experience a different kind of work from home day with some great high level networking, join us. There are only a few spots remaining, so sign up. Now we're excited to offer you today's event, which would not have been possible without our sponsor, Reed Smith, a dynamic international law firm dedicated to helping clients move their business forward with 30 offices throughout the United States, Europe, the Middle East, and Asia. Thank you. Our moderator today, Craig Lilly, is a partner at Reed Smith. His practice includes advising emerging technology companies on venture capital financings, corporate governance, public offerings, and joint ventures. So without much further ado, I will hand it over to Craig now so we can get started. Thanks, everyone. Craig?
Great. Thank you, Yvonne, for the nice words. So welcome to our event, Taking the California Consumer Privacy Act into 2021. I'm going to welcome my two colleagues, Sarah Bruno and Casey Perino, who are with Reed Smith here locally. Both Sarah and Casey's practice involves the cross-section of expertise in intellectual property, privacy, and advertising spaces. Each of us, Sarah and Casey, counsel in all areas of data security and privacy, including the California Consumer Privacy Act, the SHIELD Act, and also known as the EU General Data Protection Regulation, or GDPR. Both Sarah and Casey draft and review policies and advise on compliance and measures on commercial transactions, and also prepare and conduct trainings on data privacy, and drafting of relevant IP data privacy governance documents, and also advise strategies with clients on the collection and use of data. Each of Sarah and Casey also advise clients on the IP protection of their products and work to develop strategies for protections under trademark, copyright, and patent laws, both in the US and internationally. So I'll welcome Sarah and Casey, and I'll turn it over to you, Sarah. Thank you.
Great. Thanks, Craig. It's nice to be here, and thanks everyone for joining. Certainly when Craig approached Casey and me about talking to you all about what's been going on in California and privacy. I know Craig at the time also mentioned GDPR, and we said, Casey and I both said, well, we'd love to talk about GDPR, but there's actually just so much going on in California right now that we could easily spend way more than an hour talking to you about data governance and what you should be paying attention to just if you're doing business in California. So today we're going to focus on what is going on in California, primarily the CCPA, which has been now in effect for almost a year, since January 1, 2020. We're also going to talk about that Prop 24 you've been hearing a lot about, which is going to be voted on in a couple of weeks. It does look like it will likely be passed, and we're going to cover some broad brush provisions in that we need to focus on. Luckily, if it does get signed into law, we do have until 2023 to get systems in place to comply with that. And as we'll mention at the end, we welcome, assuming this gets signed into law, we would welcome the opportunity to meet with you and provide you with kind of more details on CPRA in the future at another meeting. So let's get started. We're going to start by talking about the CCPA. I'm trying to.
Sarah, you're muted right now.
Oh, you're still muted, Sarah.
There.
Oh, there you go.
Thank you. Sorry, when I moved the slides, it muted me. I changed the controls over. Sorry about that. Okay, so the CCPA, I don't know how many of you are familiar in the depth of your familiarity with the CCPA, but it's been out and in business here in California since January 1, 2020. When it was first announced, it was a huge deal in the United States because it was the first law that we had that had such a broad definition of personal information. And we'll get into that in the next slide. But the good news is right now, the CCPA, there are certain thresholds for compliance and not every business meets those thresholds. So the first question Casey and I always have for any company that's grappling with what to do about CCPA is, do you meet the thresholds for compliance? We've listed them here on this slide. You have to have annual gross revenues in excess of 25 million, or handle personal information of 50,000 plus consumers, households, or devices, or you earn more than half of your annual revenue from selling consumers' personal information. So those three, and believe it or not, not every company meets one of those three thresholds. What Casey and I often do is we focus on those three thresholds, and then we ask the second question, which is, well, do you have data from California residents? As Yvonne and Carol and Craig have mentioned, we're a global firm. So we have a lot of businesses that may certainly meet these thresholds, but when they drill down on the actual information they're collecting in California, they don't have to worry about compliance because they either don't have personal information from California residents, or they're subject to one of the exceptions, which we'll get into in the next slide. So personal information, and like I said in the beginning, why this was such a big deal in the US is it's a very broad definition of personal information. Before the CCPA, we had a much more narrow definition of PI in the United States, but the CCPA has taken that to another level because it's not only information that identifies an individual, it's information that's reasonably capable of being linked either directly or indirectly with an individual. What this means is that digital information and digital identifiers are now falling within the definition of personal information in the United States and in particular in California. So if you have this information from a California resident and you meet those thresholds, you have to worry about CCPA. There are some exceptions. Aggregated and de-identified information is not considered personal information under CCPA. So a lot of companies have developed systems to de-identify their information in order to avoid CCPA. Another exception is that we won't cover today, but that's helpful, is if you're collecting personal health information subject to HIPAA, then you don't have to worry about CCPA. You can focus on HIPAA and comply with HIPAA, and that information is exempt from CCPA. So if you're a business that meets those thresholds and has information from California residents, my suggestion would be to conduct that audit to determine what type of information you have and whether you are can fall within one of the exceptions so that maybe you can limit your compliance measures for CCPA. So the other part of the CCPA that was kind of a shockwave is not only do we now have this broad definition of personal information, we now have to also make sure that we're giving individuals a lot more right to control their information. So if you check that first box that you have to comply as a result of the information you collect, then you have to focus on the next box, which is, are we giving consumers the right to do these 4 buckets of rights that the CCPA has carved out for companies. And that's the right to know, the right to delete, the right to opt out of sale, and the right to non-discrimination. And so, Casey, I'll pass the baton to you if you'd like to just talk a little bit about the right to know to start.
Thanks, Sarah. Yeah, so this first one, the right to know, is kind of the bedrock of the CCPA new rights, I would say. And what this right does is it gives consumers the right to know certain details about the personal information that the business is collecting from and about them. So this right has 2 components. One is a notice component, which is a privacy policy that we're all very familiar with seeing on websites. And the other component of this right is the access right, which means that in addition to providing that public-facing notice on your website, the consumer has the right to submit a request to you asking for more specific details of the data collection. So we can go to the next slide. Yeah, so as I was saying, in addition to the privacy policy, that access right, they can request some of the things that's in your privacy policy. So categories of personal information collected, how that information is used, if it is shared, how it is shared, with whom, and for what purposes. But there's also this right to request specific pieces of personal information. So it's not enough that if I, Casey, submit a request, they say, we collect your name and email address and phone number. They would have to say, we collect your name, Casey, your email address, cperino@Reed Smith, and etc. It's a little bit more granular.
And I'll jump in quickly. I'm sure many of you already have your privacy policies. If you do have to comply with CCPA, you've already made those changes to make sure that the notice is appropriate under CCPA. Casey and I can't tell you how many times we deal with the cleanup of the fact that you post that privacy policy and then you don't do the diligence to make sure it stays accurate. So if you were one of those companies that was great and you met the Jan 1, 2020 deadline and everything's been good, it's now time to revisit that policy if you haven't already, to make sure that it remains in compliance with CCPA, because Casey and I are on the backside and that we get see a lot of the issues from companies who just frankly table it once they post it and they don't have the diligence and the systems in place to ensure they're keeping it up to speed. And then they get a letter from a regulator or a complaint from a consumer because they're doing something different than what their privacy policy says. So just a reminder to everyone, if you haven't done that and if you're in the position, please, make sure you keep those privacy policies up to date, because now we are seeing letters from the regulators to clients at this point. There's been enough time and we're seeing those letters.
Yeah, that's right. That reminds me, Sarah, thank you. I also was going to note that these are rights that apply to California consumers, but we have some clients who in their privacy policy, they either limit these rights to California consumers or they provide these rights to everyone in the US, just because from a functionality standpoint, sometimes it's a lot easier to just provide those rights to everyone rather than trying to verify residence. And so the second right is the right to delete. And this is not an absolute right. There are certain exceptions to the right to delete, which we'll get to on the next slide. But essentially, when a consumer submits a request to delete, if that information doesn't fall within an exception, you need to delete that information from your systems. And any service providers, meaning third parties who process or collect information on your behalf, you have to direct them as well to delete that information within 45 days of receiving a request. And as I was saying, there are a number of exceptions to the right to delete. Fortunately, some of these are very common sense exceptions. If I need to maintain certain information in order to complete a transaction or detect illegal behavior, to make repairs to my systems, logging of errors and bugs, these are things that you are allowed to maintain and are not subject to that deletion right, so long as you're only maintaining that information for these purposes. So I can't keep transaction information for advertising purposes. I can only keep it in order to complete that transaction, and if it falls in any of these other exceptions.
So I'll jump in, Casey, on the right to opt out of sale. And this has been probably, in addition to the broad definition of personal information and just general compliance with CCPA, this has been the provision that a lot of companies have struggled with the most. Because CCPA now requires companies that are selling personal information to give consumers the right to opt out of that sale. And the issue is that when we first heard the word sale, many of our clients were saying, oh, well, we don't sell personal information. But the issue is that the definition of sell is very broad. It's basically exchanging information for a mutual benefit. So in the ad tech arena, where a lot of companies are exchanging data for clicks, where there may not, and the clicks lead to more revenue, but there may not be an actual sale of that data, that would fall within the definition of sale, at least under current interpretation, until we hear otherwise. So what does that mean? If you are one of those companies that's benefiting from the exchange of data to provide ad revenue for your website, you're likely going to need that do not sell button on your website. And that's why since Jan 1, 2020, we've seen a lot of companies that now have that do not sell my personal information button. And you have to enable, once a person clicks on that, you have to remove their information from the exchange of data with any of those parties that falls within the definition of sale. So very important, you again are keeping on this. And this is, we now are in month 10 of CCPA. This is probably a decision your company has already made. But again, we are seeing letters from regulators now that are checking to see if companies are in compliance. And we also are seeing that clients have kind of lost the diligence of this that maybe they had in the beginning because they didn't develop a system for procurement of vendors. And because of that, they had sale exchanges that may have missed the flow with the opt-out button. And so they're having some issues with ensuring that all of their data exchanges and all their new data exchanges that have happened since Jan 1, 2020 are subject to a review and ensuring that they fall within the analysis of whether they should be subject to the do not sell link. So this is just a reminder, again, we're seeing these letters coming out from California, and a reminder to everyone that if they made those decisions and had that systems in place in the early part of the year, it's time to ensure that we're staying diligent with respect to compliance and making sure that we track the flow of our data to ensure that we're signing companies up for that do not sell link when the flow falls within it. The good news is that if you exchange data with service providers, you do not have to, those service providers are not considered a sale of data, even if there is money exchanged. The CCPA opts them out, or I call it a safe harbor for these service providers. So long as you have language in your contract that enables you to argue that they are a service provider. And that language basically says that they're only going to be using the information for the purposes of providing you with a service, and that they're not allowed to use the information outside the scope of that. Believe it or not, a lot of companies were eager and happy to include that language in their agreements. And that was, again, a part of a lot of the remediation that Casey and I did for clients, is going through all those vendor agreements and making sure they had the appropriate provisions in it to argue that they were service providers. And then two, it also separated those that said, nope, we can't include that, because when we get that data, we actually want to use it for other purposes to provide advertising to some of our other companies. And then that is where those are the ones that end up having, since they couldn't add that language, making them a service provider, they're the ones that now have to have that do not sell link and are subject to the flow of data under the do not sell link. Casey, you want to cover this one?
Yeah, so this is kind of the final right under the CCPA, and this is a right to non-discrimination, which basically means that if a consumer exercises any of the rights that we've just talked about, the business is prohibited from discriminating against them. So for instance, if I submit an access request, let me know all the information that you have on me, that business can't then say, here's all the information and you can't use our services anymore. Or you're now supposed to use a more limited version of our services. That's not prohibited under the CCPA. And then there's this other, we go back, I was gonna say there's the other financial incentive piece to that sometimes gets conflated with the non-discrimination, which is that generally speaking, you can't provide consumers with different levels of goods or services or different prices unless you can show how it's directly related to the value of your data, of that person's data, and then you provide notice of that. And then there's just a couple of extra housekeeping things here. So one is record keeping. That's a requirement under the CCPA. You have to maintain records of all the consumer requests that you receive for at least 24 months. And this little Excel spreadsheet we have here is just a simple way that a business could log. You're allowed to keep it in a log format like this as long as all of these elements are here. So the customer name, the type of request, if it's an access, deletion, etc., the date and manner in which it was received. So if you got it via email, or if they called and submitted a request, the date of your response, the nature of your response, and if you denied the request either in whole or in part, you have to document why you've done that. And then earlier on another slide, we had said that a consumer is very broadly defined as a California resident. And so that does include employees in business to business interactions, but they have provided these exemptions for employee information. And the next slide will go into business to business, where some of the CCPA requirements don't apply to this data. For instance, for employees, the only thing that you have to do is provide a notice of the type of information that you're collecting. And for B2B, the do not sell, opt out of sale is the only requirement that applies, which is unlikely that you would be selling that data in that context. And these exemptions only apply for 1 year. So they actually sunset at the end of this year. Originally, but Governor Newsom just signed 2 amendments into law that extend these exemptions 1 more year.
Yeah, and this is another, I like this B2B exemption. And this is, again, when we're talking about doing the due diligence, this is just a helpful, a lot of the clients breathe a sigh of relief with respect to this, because a lot of the community, they may just be a service provider or a company that's not actually dealing directly with consumer data. And they've been able to find that they fall within this exception because their collection of information in California is limited to an employee and an employee just talking about potentially doing business or starting something in California. And until you start dealing with consumer data in California, it's just a comfort level of non-compliance with CCPA for now. So what we're also tracking here at Reed Smith is the litigation. And believe it or not, there's been a lot of cases filed. When we started, we knew that this was going to be a very busy area of law, and we took it upon ourselves to track every case that's filed with CCPA to get an appreciation of how companies and how plaintiffs are looking at CCPA. And as was expected, so the CCPA, one of the components of it that gave companies a lot of, I guess, a little bit of comfort is that the private right of action with CCPA is limited to breaches. And if there's an unauthorized disclosure of data, that's when there can be a private right of action. So that was great news, because in the beginning that was not the case, and companies were really concerned about getting all these class action lawsuits as a result of not giving access rights or not giving deletion rights to consumers. However, as privacy lawyers, we're a little worried because we know how things go in California, and we had a feeling that there would be some creative filing there, even with this very open limitation. We knew that there would be some creative filing, and we have seen that. While a number of the cases, and the majority of the cases, are a result of an incident and a plaintiff attorney gathering a class and filing a lawsuit as a result of a data breach or an incident, we have seen some creative filings where there's claims of CCPA violations brought under 17200 of the California Unfair Competition Law, which is that broad law in California that a lot of plaintiffs' lawyers rely upon when there's practices that are deceptive, unfair, or arguably even just pricing claims or something like that. That's the law that these plaintiffs' attorneys focus on. And we are seeing CCPA claims being tossed into those lawsuits. It's certainly not the primary claim, but it's been thrown in there, and we're sure it's just as a result of them trying to generate more traction in California. Obviously, these cases are all being filed. I mean, Casey and I are getting alerts probably every day, Casey, every other day about a new lawsuit that has a CCPA claim in it. And none of them have been even started in the courts in California, especially with COVID. But we are tracking that to see what happens, and it's not clear where they will fall. But certainly, it's interesting, and it is as predicted in that we are seeing these lawyers come up with creative claims, and including CCPA. here we have just a list, and we have kind of, most of them are data. I've kind of covered this already: data security breach, we have data privacy, and then we have miscellaneous references, unlawful business practices, and then they're throwing in that CCPA claim. And the claims for the parts that we're worried about. I mean, everyone should be worried about a data incident. If you have a data incident, you should expect, and it involves California data, I can say with confidence that you should expect a CCPA claim from a class action lawyer. As a result of that, that's almost routine at this point with these filings, is if there's a public or bigger incident that we're aware of, the class action lawsuit follows. On that, the Zoom, many of us heard about the incidents that we had with Zoom early on, and I know Zoom has been subject to these lawsuits. We're hoping that that the defendants can come out of this quickly and make it easier for compliance with CCPA by having, good case law that supports the limitations of the limiting ability of companies to make, or plaintiffs' attorneys to make these claims against companies. But we're still waiting to see where that falls. But I know that Zoom probably has been really hit with these lawsuits just as a result of having more of a public incident or a public problem with respect to your data. Then you can expect some sort of CCPA claim to come after that. Some of the claims do include these notice, deletion, do not sell issues. Again, not supposed to have a private right there, so it'll be interesting to see what the courts say. We're hoping just for a dismissal, but certainly that's something we're trying here. So Casey, I'll pass this to you. You can talk about the next steps with CCPA, and then we'll turn to CPRA.
Thanks. Yeah, so for here, we just wanted to quickly note that in addition to the text of the CCPA, the California AG also releases these implementing regulations that give a little bit more color to how businesses can comply with the CCPA's requirements. They went through many drafts of the implementing regulations and released the final proposed regulations on June 2nd, which were approved by the California Office of Administrative Law on August 14th with a few minor revisions. But then just a couple of weeks ago, we can go to the next slide, a couple of weeks ago, the AG issued a third set of proposed modifications to the regulations with a couple of tweaks to what they had already said. For instance, that the opt-out mechanism has to be easy, like a one-click opt-out, rather than having the consumer go through multiple levels to get to that opt-out of sale. And these new proposed modifications are available for public consultation until 5 p.m. on October 28th, 2020. And part of the reason why we just wanted to touch on these final regulations is because we're about to speak about the CPRA, and the final regulations are barely 3 months old. The CCPA is less than a year old, and despite all of this, California voters are currently voting on a ballot proposal that will significantly amend the CCPA.
That's right. So I'm glad we have about 20 minutes to cover the CPRA. And as I said at the beginning, this is a huge topic, to be fair, because I'd say the CPRA is closer to the GDPR than the CCPA is. And when the CCPA came out, we actually said it was very similar to GDPR. Well, the areas where it was less similar now have been tied up by CPRA. So we're seeing an even broader law in California. And again, when you approached on this, I think it was a month or so ago, at that point, we were less hopeful that CPRA would be signed in. And now, I mean, the news looks like every day where the polls are showing that this is likely going to move forward. So I do think, assuming this does sign in, we'd be happy to have a more in-depth conversation about this with you all. But for now, we'd like to get into a little bit and I'm going to actually move to the next slide. This is the background, which Casey generally just covered. And now, like we know that in November is when we're going to find out if this is moving forward or not. And we'd like to spend just the time going through the CPRA. So I think the first and most important part is the CPRA is, as I mentioned at the beginning, personal information was brought under CCPA. Now we have an even broader definition of personal information under CPRA, and that they've carved out sensitive personal information, and they've put more robust requirements on companies when you're collecting that. It's not just social security number, driver's license number. It is that, but we already kind of were worried about that under CCPA and just under the laws in the various states anyway, because this has always been sensitive information in the United States. Most states have laws that cover the collection of sensitive personal information. How they cover it is if you have a data incident and you're collecting that information, there's a lot more notice requirements associated with it. Also, if it's health information, you've got HIPAA. Some states do have, if you're collecting driver's license, social security number, you do have to either encrypt that information, or you may have requirements to have a security document that's governing the use of that information. And Massachusetts in particular, there's a lot of requirements for sensitive information. The SHIELD Act in New York has a lot of requirements for the security of financial information. So we already were, so when a client comes to us, we already were worried about sensitive personal information. The difference with CPRA is it goes a step further, because it says things like your sexual orientation, information that you would consider as more personal, but may not fall within the definition of sensitive information, what your sex life is like. Things like that now are clearly considered sensitive personal information under CPRA, which means that we're going to have to, when we're getting that information, we're going to have to worry about CPRA and making sure we have the appropriate notice, and we may have to have opt-in consent to use of that information. And we're also going to have systems in place for data retention and minimization. So what does this mean? You already likely did a data audit inventory under CCPA, and you may already have this completely buttoned up, and but you should do another data. You should be doing data audits every 6 to 9 months, no matter what. But once we're getting ready for CPRA, you want to do that audit, and you also want to make sure you've broadened the audit to include the new buckets of sensitive personal information that are covered by CPRA. Okay, so moving forward, there are certain compliance measures with sensitive personal information, which we can get into in more detail, like I said, at a later date. But for first round of this, we want to just let you know that is one of the big changes with CPRA, is that we now do have this broader definition of sensitive personal information, and consumers are given more rights to control a company's use of that information. The CPRA also gives consumers new rights, the right to correct their data, which is currently something the GDPR enables. Also, the law in Singapore enables that too, gives consumers that right. Now we're going to have, if CPRA is passed, we're going to have consumers in California have that right to write into a company, and it's likely going to be through that access request. And they can then request to, 1, see what data you have about them, but 2, ask that you correct something. And this, again, could be very important with respect to sensitive personal information. You can imagine a lot of consumers are going to want to know what sensitive personal information you've got on them. And then they're going to likely want to either correct or possibly delete certain parts of that sensitive information that you have. And now they're going to be given that right under CPRA. So I've been talking a lot. Casey, do you want to cover service provider obligations?
Yeah. Can I also just quickly say one of the other new consumer rights that I think is very unique under CPRA, and that isn't seen anywhere else, is the do not sell is expanded to do not sell or share, which I think will have far-reaching implications for companies who are already struggling to comply with the do not sell. Now it's very explicit that it's do not sell or share with a third party. So that's just another fun one to grapple with if CPRA comes to pass. But for service providers, as Sarah was talking about earlier in this presentation, under the CCPA, businesses have to have these contracts with service providers in order for those third parties to fall within the service provider bucket. the CPRA mandates even more specific language that has to be included in those contracts. For instance, they have to grant the business to the right to take certain steps to ensure that the service provider is in compliance. They have to notify the business if they're not able to comply. They have to provide reasonable assistance to the business for the business to be able to comply with their obligations under CPRA. And then also another new thing with service providers is that the service providers, if they have service providers or contractors, they have to have a similar contract in place with their service providers or contractors that the business has with their service providers. That's a little complicated. It's a mouthful, but but essentially, Sarah and I already put a lot of these protections in place in our contracts because it's good business practice to do that. But now it's a mandated requirement under the CPRA, or it will be.
Yep, and I'll jump in now to cover ad tech. And Casey, you actually nailed it with my first point with ad tech, which was the do not sell is now brought in to do not share. So in the beginning, when I was talking about the exchange of data and that do not sell link and how that really impacted a lot of digital advertisers, the do not sell has now been brought into share, which again is really going to have an impact on the ad tech. And so, a lot of companies are still trying to get in shape under CCPA. So now, luckily we have time. We have 2 years for CPRA, assuming it gets signed in. But now we have an even broader definition of to cover the exchange of that data. And so, if there was some creative arguing that there wasn't selling going on under CCPA, I think this could make it more difficult for the ad tech companies because of the sharing component. They also have broadened the right to know under CPRA. And so a more robust notice is required, which I think this will impact the ad tech industry as well, because oftentimes those collecting parties are just on pixels or cookies. And if that's the case, we have to think through the notice requirements there and whether more broader and more robust notice requirements are going to fall on a company that's possibly not in a good position to provide notice because they're on the backside of the data collection or the second party collecting the data after the publisher of the website. In addition, I already mentioned data retention. Some states already have requirements for data retention. Now we have under CPRA, we'll have more robust requirements with data retention and making sure you're only maintaining data for the purposes for which it was collected and not beyond that time period. You also are going to have to tell consumers what the time period for the different pockets of data are that you're retaining about them. So that's, again, more thought, more analysis that goes into your data inventory, because now you're not only thinking, what do we collect? You have to also be asking the questions, how long do we need that data? And what's our system for deleting it when we no longer need it? In addition, and we mentioned the GDPR here, we have to have opt-in consent in some instances for, again, more sensitive data. In addition, another component that's similar to GDPR is if you're doing what they what's been called riskier or riskier processing, which sometimes can be behavioral tracking. It also can be associated with more sensitive data. Then in those instances, you have to do a risk analysis to determine what the risk is to the consumer for that and keep a record of it. The GDPR already has that requirement, but now we're going to have that under CPRA as well. And again, there may be other hoops you're going to have to jump through once you determine that you've got this riskier processing. The purpose for your processing is a little bit more risky, then you're going to have more hoops to jump through under CPRA. That was not part of the CCPA before, so this is all going to be new ground for companies that are US based that may not have had to worry about this because they weren't doing business in Europe. Now they're going to have to be doing that in California. Okay, so we talked in the beginning about the thresholds for business. They actually, the CPRA has expanded it to 100,000 consumers or households versus 50,000. That may be helpful for some from some companies, but again, these are details that can be flushed out. I know that some of the clients we work with may have a general idea and may have had some comfort in that 50,000 number, but most jumped that quite quickly. And so the 100,000 may be a helpful broader requirement that eliminates some of the compliance measures for companies. Casey, since you covered the B2B exemption, do you want to talk about the next one here?
Yeah, so I mean, oops, sorry. Those bills were signed into law that extends those exemptions until 2022. But if the CPRA is passed, then those bills don't go into effect, and instead the CPRA extends those exemptions until 2023. I think the thought there is to allow businesses plenty of time to get into compliance for those buckets of data that might be a little bit trickier given the use of that data.
So we have a lot of time, and the good news is when CPA was announced, we didn't have this much time. So luckily, most companies are now on their way to compliance with CCPA or in compliance with CCPA. We can't stress enough that if you were one of those lucky companies that felt like you were good to go January 2020, you should be revisiting everything routinely to make sure you remain in compliance. Because the letters are going out and we're seeing that. And two, that you do have more time here. We have until Jan 1, 2023, although it will apply to PI collected after Jan 1, 2022. So we have some time to get into compliance with CPRA. And like I said, we're happy to give a longer and more detailed presentation on CPRA. Now it's looking like it will be signed in. And if that's the case, we'd be happy to do that for this group with more of a breakdown of the requirements and kind of almost give a training on our suggestions and practical guidance for compliance with CPRA. And I am very happy because I wanted to leave about 15 minutes for questions. We did move quite quickly through that material. And so happy to spend more time on anything. We have 15 minutes now.
I have an initial question. I thought under the CCPA that you have, if in order for like a private person or someone to make a lawsuit against a company for a breach, they have to give you like a 30-day written notice and cure period before you can actually sue. Is that correct?
So the regulators have a 30-day cure. And we are actually in some of the letters we're seeing, Craig. They're timing it. So that's right. There's a 30-day. The private right of action is really for a data incident. And that doesn't necessarily, there's no cure period there. The regulator is the one that has the cure period. And so one important note is the letters we're seeing in California, they're coming to the privacy inbox, or they may be just, if you don't happen to have a good email address in your privacy policy, just with COVID, it can be tough. So make sure you're monitoring for those letters. We've seen how they can get lost in the shuffle, just given the fact that there's not really people in offices right now. So for this group, just another comment would be checking to see where any correspondence related to privacy is going. I'm sure if you're already in CCPA compliant and feel great about it, then you probably have a privacy inbox that you're routinely monitoring. But if you're one of the companies that determine for some reason you don't have to comply with CCPA or you don't have data that puts you in the bucket, but you do have an email address on your privacy policy, just make sure you still have someone monitoring it because those letters are coming to those reference points.
I noticed you mentioned like the number of lawsuits, under the CCPA. Does that also include like the AG, Attorney General enforcement actions as well? Or?
No, because we don't, those are confident, at this point, they're inquiries, Craig, that are being sent to companies with that right to cure period. And we haven't heard of a public, nothing's gone public yet from the AG's office on that. Well, yeah, generally. There's some, I guess they've been bragging about some of the letters that they sent out. So there's been some public notation, but as far as where the enforcement's going, the clients that we're working with are not, that are just getting those letters and trying to cure whatever has been complained about. So.
We have one question from our chat, questions is a very broad question. What companies will this impact the most? I mean, it seems to me anybody who manages data is going to have major issues with this.
Yeah, I think from my feeling, the ad tech industry, the tech industry are really the ones that are really under the gun with CCPA, and then CPRA will be even worse. And that's just because, again, the definition of personal information is so broad. Like I said, during one part of this, we had already had, if a company was collecting driver's license in the United States, they already were developing systems to make sure that they're protecting and securing that data, just because there already were incidents that we were dealing with. But now, because we have that broader definition of information, companies that are collecting information by social media they've been really struggling with CCPA, because they may be allowing you to just post, the only information they collect is your name and email address. And then on the backside, they're collecting all this tracking information to see what sites you go to, what you're interested in, so that they can deliver you ads. As a result of CCPA, those are the companies that have had to really buckle down with in either making sure they fall within the service provider safe harbor, or they have that do not sell link, and they're tracking the flow of data and providing notice and all of the different requirements of CCPA. So that's the, I'd say if you're in the tech industry, CCPA is definitely something you should be worried about as in addition to CPRA. And then next up, if you just have a lot of broad stroke consumer data from California, you should be worried about CCPA and CPRA.
Yeah, and then also, I guess, the damages can be $750, I think, per violation, or up to that amount. So how do they calculate? I mean, that's per individual violation. So those damages can ramp up fairly quickly. Is that right? Or when?
That's right. Yeah, Casey, you're nodding. I've been talking a lot.
I was just gonna say it's per consumer affected. So a good example to think about would be in the data breach context, that it would be $750 per consumer affected. So if you had 100,000 people's information, that would be 750 times 100,000. So those do add up in the breach context. And then I believe for just regular violations, it's 2,500, and then intentional violations other than breach is a little bit higher than that per violation.
Yeah, and CPRA is actually expanding those as well. It's another part of CPRA that they want to have the penalties be a little bit higher. And the question about who should be worried about this, also, if you're collecting information from teens, that is also something we should highlight. CCPA right now requires opt-in consent from teens if you're selling their data. So again, social media users, TikTok, if you've decided that if you're a company that has a lot of teen users and you're enabling ad revenue as a result of the platform you're on, you would have to have that opt-in. And so to answer the question, we got a few, teen data is now a bigger deal. And we've worked with some companies that are really struggling with that, because they collect, for example, a fashion brand may have mostly adult shoppers, but then they also have some clothes that are attractive to teenagers. So suddenly they're having to have either everyone opt in, because a teenager is required to opt into the sale of their data, or they have to make the decision of somehow segregating teen visitors from adult visitors, because adults, remember, only have to opt out of the sale of their data. So that's just an important thing to flag.
And another question, I guess, from the group is, you've already touched, I think, on the requirements. We could go back to this, is, what about, small, medium kind of businesses, the mom and pop businesses that maybe have 15 retail outlets, and they're not necessarily like a tech company. Maybe the example was a tire shop and stuff, and they have personal data. maybe you could walk through the requirements at least again for that example.
Yeah, and I'm actually going to toss that to Casey because I know she works with a company that has that footprint in California. So go ahead, Casey.
Yeah, so I think here what's important to understand is kind of the size of the business is less important than whether it meets these thresholds. So for CCPA, those thresholds are $25 million in gross annual revenue, 50,000 consumers, you're collecting the data from 50,000 consumers or devices, or 50% of your annual revenue is derived from selling personal information. So you could foresee a small business, a mom and pop tire shop that has 15 stores in Northern California. Maybe they do collect information from 50,000 or more customers, and then they would be subject to the CCPA because it's just one of those buckets that you need to fall into. And then for CPRA, they're trying to be a little bit friendlier to smaller businesses and upping that 50,000 threshold to 100,000 consumers.
And so I guess just jumping in, the requirements are the same. So even if you're a mom and pop shop and you meet those thresholds that Casey listed out, it's the same requirements. Some advice would be looking to see if you can de-identify data. If you're just on the brink of compliance and you're struggling as it is, look to see if you can de-identify data because that can, again, then it's not personal information, and then you avoid a lot of the headache with CCPA.
And also, I'll just also quickly note that some of the requirements the CCPA takes into account how you interact with your consumers. So if you are a tire shop and you don't have a website at all and you're just a brick and mortar with a phone number, then some of the notice requirements would be through those channels rather than, they don't require you to create a website and post a privacy policy.
I guess one last question. What if a company inadvertently does do a breach, which triggers this? I know there's that 30-day cure period, I guess, with respect to the AG, but I mean, what type of corrective actions can the company make to minimize their liability?
That's a really good question. So the first step would be, if you're a company that's had an incident and it becomes public, it's going to be, that's a train that's already gone. And it's going to be hard, Craig, to minimize the ramifications. When I'm working with a company on a data incident, the first thing we, and Casey knows this as well, we really hammer down on when that notice goes out and whether we have to, how public we go with that notice, because it is a lot of the incidents, the majority of incidents that we see don't require notification when you drill down on what has happened in the incident. And a lot of companies end up publicizing it very quickly because for a variety of reasons. It may become public because someone inside complains. It may be public because it's a ransomware attack and it gets published in the news as a result of that. So a lot of times that's not something you can control, but if you're in the position where you can control how public the incident becomes for CCPA and CPRA, we strongly suggest you do that, because once it becomes public, there's really, you need a PR, you need someone from your PR team helping you control it. And then as far as minimizing, it would just be making sure that you're responding to the incident appropriately. And again, this could be a long topic for a conversation, Craig, but just controlling the incident and responding to the incident appropriately can help minimize the damage. But lawsuit will still likely be filed. I mean, that's what we're seeing in California. You're still going to get a lawsuit. Maybe you can get out of the lawsuit more quickly by establishing that you took care of the incident appropriately and make it go away quickly.
Well, great. Well, thank you very much. I think we're now near our 1 o'clock for the end of our presentation, but I don't know if anyone else has any further questions. Then we'll wrap this up. But thank you, Sarah and Casey, for the presentation. It was really helpful, and looks like there's more to come in the data privacy aspect, especially in California. So we look forward to hearing from it in the future.
Yeah, thanks for having us.
Thanks.
Thank you, everyone.
Yeah,
Okay.
I second that. Thank you so much for the presentation and the helpful information that you shared with our community. So
Yeah, feel
everyone,
free
thanks for
to
joining us.
take the slides. Yep. Okay, thank you.
Yes,
Thank
Carol
you.
will
Okay.
be sending those out. Perfect.
Yep.
And
Great.
remember, if you are in the mood to play some golf, sign up. I'll see everyone soon. Have a great afternoon.
Great.
Bye-bye.
Okay.